Hello, dear all. This is Anurag Shrivastava, myself lecturer with the Department of Public Administration, School of Liberal Studies, Pandit Deendayal Petroleum University, Gandhi, Nagar. Today I am going to deal with another topic, and that topic is concerned to democratic decentralization through 73rd Constitutional Amendment Act 1992. I hope that you must have heard what democratic decentralization is all about, but in order to get you a basic comprehension, I am just telling that I'm going to tell you that democratic decentralization simply suggests that how democracy is going to be decentralized and how it should be made available at the grassroots level. As you know, before 1992, we had only two tiers of government structure in India, that is the union government or central government and the state government. And after 1992, we had added another tier, that is the third tier, or that tier is known as the local government in India. 73rd Constitutional Amendment Act deals with the Panchayati Raj institutions in India, and 74 deal with the municipal bodies, urban local bodies or municipal bodies in India. Just to brief you regarding the necessity and the need of this act and the previous attempt which have been made in regard to this 73rd Amendment Act, I would like to add that it was the Alam Singhvi Committee, great constitutional expert, in 1986 which for the first time recommended for constitutional status to the Panchayati Raj institutions in India. As you all know that the first Panchayati Raj body in India came into being in the Rajasthan on 2nd of October 1959. But even from there onwards, states had adopted different patterns. There was no uniformity. No spine was being accorded to the Panchayati Raj bodies. They were dismissed at any time by the sweet will of the state government. There was no regular or periodical elections, no financial provisions. So it was high time that government should be taking certain kind of initiative in this regard. And in order to achieve this or to implement this initiative, the 73rd Amendment Act came into being. Through this Amendment Act, things have changed as far as Panchayati Raj is concerned in particular, and the local self-government is concerned in general. It was Narasimha Rao government which introduced this constitutional amendment bill in Lok Sabha in September 1991. It was passed by Lok Sabha on December 22nd, 1992, and by Rajya Sabha on 23rd December 1992. And later on it was approved by 17 states, more than 17 states, and finally on 20th April 1993, the Panchayati Raj was assented by President of India. Now, you must be wondering what was the need of this uniform law or this uniform legislation, and as you all know that why central government took this initiative, in the sense because the local self-government is part and parcel of state government. As I have already mentioned that the need was there because it was haphazard, it was not structured, there was no power to the Panchayati Raj bodies, there was no financial devolution which was there, no elections, no democratic element involved. Hence, central government had to take this initiative. So, it may sound ironic, but this is the reality in the sense that central government took the initiative for creating a law which is mentioned in the state list. And for that law, this 73rd Amendment Act was constitutionalized. Now, it contains 29 functional items regarding the panchayats and all. 73rd Amendment Act has added Part 9 to the Constitution of India. It has added articles from 243 to 243O. It has also added one schedule, that is 11th schedule, to the Constitution of India. And you must be aware Article 40 of Indian Constitution, and which is basically attributed to the Gandhian philosophy and the directive principles of state policy. Article 40 simply suggests that states shall make attempts to organize village panchayats. So somehow the Panchayati Raj in India through 73rd Amendment Act has got this constitutional backing by Article 40 also. Uh, Under this act, the state governments are now under constitutional obligation to adopt the new Panchayati Raj system in India as per the act. Neither the formation of the panchayat nor holding the elections at regular intervals now depend on the will of the state governments. There are provisions they have to adhere as far as 73rd Amendment Act is concerned. These provisions have been grouped in two categories: compulsory and voluntary provisions. The compulsory provisions of the Act are uh, dealing with elections, financial provisions, representation of these people from the scheduled caste, scheduled tribes, and backward classes of the society. Now, in order to be specific about the salient features, the 73rd Act has given three-tier structure, and it is known as Panchayati Raj in the states, and it is divided or it is categorized like Panchayat. First stage means an institution by whatever name called of local self government for rural areas, village, which you all may be aware of, a village specified by the governor through a public notification, and intermediate level between the village and the district. Again, that is through the governor's public notification for the same. Act has brought uniformity, I have already mentioned, and it has given one criteria, and which is in favor of smaller state. The state which are not having or exceeding 20 lakhs population, they need not to constitute or create the intermediate level. It talks about, this act talks about Gram Sabha, uh, which is the foundation of Panchayati Raj system in India. It consists of persons registered in the electoral rolls of the village comprised within the area of the panchayat at the village level. So all the registered voters are supposed to be part of Gram Panchayat. The act also provides a 5-year term to the panchayats. If at all they are dissolved before their completion of their term, the fresh elections are supposed to take place within the 6 months from their date of dissolution, or in case of dissolution before the expiry of a period of 6 months from the date of its dissolution, or before the expiry of its term. It talks about that disqualification cannot be, no one can be disqualified on the ground that he has attained he is less than the age of 25 years. That means if somebody is contesting the election of Panchayati Raj and he is of 21 years, he is suitable enough to contest the elections. The act has also provided reservation for scheduled castes and scheduled tribes in proportion of their population in the panchayat area. It has also provided reservation for the women's. 1/3 seats should be reserved for the women, including the number of seats reserved for women belonging to scheduled caste and scheduled tribes. State can also make attempt for reserving some seats for the backward classes. It talks about the election of the members and the chairperson. All members of the panchayat at the village, at the intermediate and district level shall be elected directly by the people. The chairperson of the panchayat at the intermediate and district level shall be elected indirectly from amongst the elected members. The chairperson of a panchayat at the village level shall be elected in such a manner as the state legislature determines or deems fit. It talks about the State Election Commission. You must have heard Election Commission of India, but Election Commission of India is not involved in the conduction of election of Panchayati Raj, or through, as per this act, there is a State Election Commission which has been given the responsibility to conduct the election. Similarly, for finance, the State Finance Commission has to be created as per this act to recommend for the measures of the sharing of taxes between the state government and the local government, to assign or to look into the grants in aid which are supposed to be flowing from the consolidated fund of the state to the local bodies, Panchayati Raj bodies. And then the Central Finance Commission shall also suggest the measures to augment the resources of the local bodies or Panchayati Raj bodies in India. There are certain exceptions where the 73rd Amendment Act did not come into being, such as Jammu and Kashmir, Nagaland, Meghalaya, Mizoram, and certain other areas of the country, because of their special and geographical position. For example, in Manipur, district council is existing. That is why they have excluded it. Clear? The date of commencement of this act was 24th of April 1993. Thank you.